So, um, the issue with this statute is very specifically in regards to it's the torture provisions of 42.092. And what I mean by the torture provisions is in 42092 B1, it says that if you commit torture or in a cruel manner kill or cause serious bodily injury, that provision, we're limiting it to the torture because the state has not alleged cruel manner of death, killing, or serious bodily injury. The definition of torture is an unjustifiable, an act that's causes unjustifiable pain and suffering. And while that might sound, sufficient, it's super, super vague. And it becomes even more vague when you look at the rest of the statute and how in the allowable conduct that it permits under the statute. So I do have a copy of the statute. It's actually for the court. It's actually chapter 42, most of it. It's gonna include section 4209, cruelty to livestock, and then right behind that, it's gonna include
Oh, I'm sorry, you gave me 2 copies.
okay,
I don't know, the state may need an extra one. Thank you.
do y'all need an extra one? Okay. And then right behind that, you'll find the cruelty to non-livestock at 42.092. When you look at these statutes between livestock and non-livestock, they are identical in regards to the torture provisions. The only difference is that livestock is limited to intentionally and knowingly, whereas you have the mens rea, and then non-livestock allows you to go to recklessly. So that's the only difference is the mens rea. The definition of torture under livestock, cruelty to livestock and cruelty to non-livestock is the exact same. That's important because when we look at what our society has determined is acceptable or justifiable pain and suffering, we have to understand that the context is the same regardless of whether the animal is non-livestock or livestock, even though this is pled under the non-livestock provision. Okay, then turning your attention to the actual statute of 42.092, I want to bring your attention to section B and B2. And it says a person commits an offense if the person intentionally, knowingly, or recklessly, without the owner's effective consent, kills, administers poison to, or causes serious bodily injury to an animal. So by implication, if you have the owner's effective consent, it is not illegal to kill, poison, or cause serious bodily injury to an animal. Then if you proceed downwards, it allows under B6, it allows that someone, if they have the effective owner's consent, to cause an animal bodily injury.
So are you saying that according to this part of the statute, if you are a pet owner, then you can poison your pet, you can beat your pet, and that's not a crime?
And that's what is concerning about the absurdity of this statute, but that is the statute. Basically what it's saying is if somebody else does it to your animal and you give them consent, it's okay. But read it, and that's what I'm saying. It says under B, a person commits an offense if the person intentionally, knowingly, or recklessly, without the effective consent of the owner, kills, administers poison, or causes serious bodily injury. So they can do it. It's not as long as they have the effective consent of the owner. So
isn't that related to if you take your doctor in for veterinary care? Well, you euthanize, have the animal euthanized, that you're killing the animal and the owner has given consent?
And that's a great question. But if you look further, it actually has a provision that deals with the like a veterinarian services, and let me see, it is a defense on D.
Mhm.
It is a defense under that if the actor had a reasonable fear of bodily injury, if the actor was engaged in a bona fide experimentation of scientific research, or under E, if it was discovered on the person's property, or two, the person killed, injured the animal within the scope of the person's employment as a public servant. And then it goes on, sorry, which one is it? So I don't think that well, I think that's a great question. I don't see the actual, well, but it's a public servant. So, I mean, I don't see where it says actually a doctor, but you see what the problem there is, that you, by saying, oh, that's just to allow a doctor, it is not limited under the statute for that purpose. It's saying anybody. And when you look at animals, animals are considered under our or under our laws as chattel, as property, which is just the way our society has defined them. Whether I agree with it or I don't agree with it, the civil courts will not allow you to collect money, civil damages, if you, for the loss of your emotional attachment to a dog. And there's a case that we have on that. It's cited in the paper. We can provide that to you. So what they, and they do a great job of.
Well, that's civil.
I
We're
understand.
just here under the penal code.
Yes, Your Honor. And so, but the point is that the status as property is what is triggering the owners, why you have to have the owner's effective consent, because our laws, whether they are civil or criminal, still see animals as property. They don't see them as having the same rights as a human.
But are you even with regards to this section that says without the owner's effective consent, are you arguing that you can still kill an animal in a cruel manner?
I'm not arguing that. I'm saying, yes.
Or cause unjustifiable pain?
So that part I am arguing with, because that is so broad as to undo all the other rights that you would have. Because when you say unjustifiable pain, does that go to emotional pain? It's not limited. It doesn't even under, and that's why this is going to become such an issue throughout the course of this trial, is because if, as in our case, there's no bodily injury, then you are saying that the law allows for us to criminalize acts that someone just calls a dog unjustifiable pain and suffering without requiring any proof of bodily injury. Humans don't even get that level of protection. You know, humans, you can't be charged for having caused someone emotional, like with a crime, for having caused them emotional injury.
Is the indictment, are you all charging this indictment as causing emotional pain to the animal?
No, Your Honor, the indictment's charging under the first section under D1 that says torture.
All right. So they're not, my understanding, and if I'm wrong, please correct me. My understanding is nobody is charging her with causing emotional pain, allegedly causing emotional pain to an animal.
So if you have no bodily injury to an animal, then what's left?
Isn't that a fact issue for the jury?
No, I don't believe so. I believe that our law will not allow, like written as broadly as it is in conflict with every other provision that we have in our codes. Because if you look at the bodily injury, like for instance, a human assaulting another human, we specifically state in our definition of bodily injury that it is the
Causing pain?
Yeah.
Is one of them.
Well, it's causing pain, but the thing is that it also it will not allow for someone to be criminally prosecuted for emotional harm or pain. And we distinguish that by saying that it has to cause bodily injury. Here, the problem with this statute is that that torture provision does not require bodily pain. If anyone shows that there was no bodily injury, whether, and it's a different topic, whether you could include pain or it would require physical bodily visible, some type of visible injury, that's a completely different issue. But just assuming for the sake of argument that if we are going to require and limit assault to bodily injury on a human, we definitely can't not require it for an animal who, under our laws, has historically and still today gets less protection. I mean, a prime example is our horse racing. We have animals that are routinely raced and beat with crops. And the reason I bring that up is because this one specifically names repeatedly striking a dog. That's the manner in which they claim. So the point is that our society has said it's justifiable to beat a horse with a hard crop for horse racing and making money, and that's justifiable.
Well, that's something that needs to be taken up with the legislature on the fact that maybe people don't want horses being beaten. I know some people complain about maybe in other countries, dogs are eaten for food, but then people have a different idea of how dogs should be treated as opposed to livestock, as opposed to horses, as opposed to chickens. But that's something for the legislature to change how different animals are treated and how they're treated in sports. So my understanding, and again, if I'm wrong, correct me if I'm wrong, the state is not charging your client with emotional abuse.
No, Your Honor.
So my understanding there that the indictment doesn't mention emotional abuse. And I know you're saying torture, but my understanding from this statute and from what the state is saying, they're not charging your client with emotional abuse of an animal. They're charging her with allegedly, recklessly causing torture or committing torture.
So first, let me back up and say that the legislature has, in their infinite wisdom, not distinguished between livestock and non-livestock for purposes of torture. And so we cannot say that animals, livestock should be treated differently than non-livestock. They all are examples of what a collective class of they're a collective class. So we can't distinguish it that way. But what the problem is not whether the state sits here and tells us what they've charged. It's that the statute itself, the underlying statute, is so broad as to encompass or not eliminate the ability for someone to be convicted, including my client, of an instance in which all that happened was, if anything, emotional harm to an animal. And that's the problem with the statute. Whether the state claims that they weren't trying to, convict someone for emotional harm, it's that when we get to the end of this and that jury charge, and I go and ask the court, hey, how are you going to keep them from convicting on emotional harm alone? The court's not going to have an answer because the legislature didn't give us the tools.
No, here's the thing. I'm reading the indictment. The indictment is stating intentionally and knowingly, recklessly torturing an animal. Like if the state were to just have left that as says torturing an animal, I would say your client really doesn't have notice. What are they talking about? But then in the indictment, it says, namely a dog, by repeatedly striking the dog. There's no mention in this indictment about emotional harm. And whether or not you believe a jury may or may not find somebody guilty because they're thinking about emotional harm, that's something that you'll need to argue with the jury.
And Your Honor, and that's where I'm saying I have an issue with the law itself. That's why it's filed as a motion to quash, because this is something that a jury, it can't comprehend how the laws are structured in our country. I mean, they haven't studied the laws like we have as lawyers.
But isn't that what a jury charge is for? I tell them in a jury charge what the law is, and they have to follow the law.
Yes, but you told them, and right now what I'm explaining is that there is no limitation on it being. So if what the court if I'm understanding your question correctly, I think your question is, hey, can a jury convict on emotional harm? And that's the issue, because it is read that broadly. You're not going to be able to tell them no. You're not going to be able to tell them you must find at least bodily injury, whatever, however that's defined, because we as a society do not find emotional injury to be like a criminal act. It would be criminalizing non-criminal conduct if we are saying you can convict on emotional harm alone. And that's the problem, is that when I ask you for the jury charge, you're not going to be able to give me a jury charge that is in line with how it is supposed to be. In my opinion, it is supposed to be limited to bodily injury, but you're not going to be able to do that because the law is absent or silent on that. And also further, if we are to say, okay, well, it's silent, we can look at, and section under Texas Penal Code 105, it tells us that we are to read these statutes, these provisions, in line with the whole context of the Texas Penal Code to be a fair interpretation of the statute. And I have a hard time believing that the legislature allows us to give effective consent for someone to cause our animal bodily injury or kill, poison, and cause serious bodily injury. But they're like, but you can't cause them emotional harm, and that it goes that far. And so what I'm saying is that if there is a way that the state could have indicted this that would have limited it and applied it the way it was probably intended to be, they would be causing that they cause bodily injury by repeatedly striking the dog, because they then, in their manner and means, have limited it and said, look, we're talking about bodily injury here. We're not talking about whether the dog was traumatized with no bodily injury.
All right, state.
Your Honor, the definition of torture, we would argue, is intentionally broad because there is a wide variety of means at which an animal can be tortured. So in this situation, in McGinnis v. State, the court focused on the words unjustifiable to conclude that yes, under the law, there are some instances where infliction of pain and suffering is allowable, which is why the state must allege specific acts that were alleging the torture occurred through. So the court in Hacker v. State, as well as Cross v. State, said we need to allege those specific acts, as well as interpret the words unjustifiable, and in that case unnecessary, based on their common usage, because it's not defined. The state has done that here by including the clause by repeatedly striking the animal. Further, courts, when interpreting torture, they have looked at the physical condition of the animal and the side effects of that treatment. So in Solinsky, the court found that the nature of the condition of the cats by putting them in the microwave constituted torture. And in Bell v. State, they also found torture when the defendant amputated the puppy's ears without providing anesthetic and antibiotics. Those questions, whether defense finds the torture alleged sufficient based on, pigeonholing us into proving bodily injury of the dog, would be a question of fact for the finder of fact, so the jury. To fix, quote unquote, fix the indictment by adding bodily injury would be adding language that's not required by statute. And we would have been here in the same position arguing against a motion to quash for adding language that isn't there. We must only prove torture, and torture is any act that causes unjustifiable pain or suffering. Even using the definition of bodily pain that defense thinks that we should have as the scope for torture in this case, it's physical pain. Pain doesn't always leave a mark. It doesn't always require physical injury for someone or something to feel pain. In McCall v. State, the appellant challenged the constitutionality of the animal cruelty statute as vague and indefinite, relying on Senator. In Senator, they found that the provision there regarding needlessly killing an animal as unconstitutional. However, the court in McCall said that the court in Senator expressly only said that one provision of needlessly killing was unconstitutional, but that the statute listed and enumerated other ways that are sufficiently definite. So by tracking the language of the statute here, we would urge that our indictment is sufficient. And then by using torture, which is under B1, and then adding the manner and means to provide adequate notice. Regarding defense's argument about property rights, we would urge to you that animals, yes, they are property and they do typically have less rights than humans, but we'd extend that to say that they need more protections because of that reason. When somebody owns property, they own it under the guise that it might involve adjustment of that rights for public good. The whole purpose of this statute is that it criminalizes an act that causes unjustifiable pain and suffering. One can't own property and not have their rights sometimes yield to the government's legitimate exercise of its power to prevent harm to the community. We would just urge, Your Honor, that the statute is not unconstitutionally vague and that any issues regarding what may or may not be torture would be a question for the jury.
All right, and defense, it's your motion, so I'll give you final argument.
Well, and Your Honor, I still have, there's other
Sure.
things that we need to address. So I would like to provide y'all with a copy of United States versus Stevens, in which they dealt, the federal government dealt with a statute very similar to this one. In fact, it was more specific. It said that the statute required proof of being maimed, mutilated, and tortured. And this, let me see, the US Supreme Court said this statute is unconstitutionally vague, and they explain why. And torture is even as defined as unjustifiable pain is even more vague, because when we look at all the ways our society allows us to put bark collars on dogs, they allow racing, they with the crops, they allow branding of an animal, they allow and none of this, like when you take pigs, little baby pigs, they cut their ears and they do it deeply enough so that it can't heal again back and close back up. They pull their teeth without anesthesia. They crop their tails. They do this thing called mulesing to sheep, which they take scissors and cut off their back side so that the hair won't grow and they won't get infected. I mean, we do very, very painful things to these animals without anesthesia, and they are accepted. Museling is not illegal in the United States. And what I am afraid of is that in the United States, we feel that a parent has the right of discipline of a child, and there is no provision in here for discipline of an animal. And this statute as written is so overly broad that unjustifiable pain and suffering, I mean, unjustifiable suffering, someone might think crating your dog is unjustifiable suffering because they personally see it that way. This is so broad as to not give an ordinary citizen notice of what is actually actionable. And I would also bring the court's attention to this. Every case that I've looked at with torture has a severe degree of depravity. It is not, and it doesn't come without bodily injury. I have not found a case that has no bodily injury. And so if this statute is broad enough, because pain is so broad, pain encompasses bodily injury and emotional injury. If it's so broad, you have now allowed the jury to, because of the breadth of the statute itself, to convict for what we would consider acceptable behavior in our society: crating, leashing, bark collars are sold, shock collars, shock prods. I mean, we don't treat animals the same way that this statute is as written, the breadth of its statute could reach. Hold on one second. Yeah, and then also when you look at the term for torture, it says includes. It doesn't say is any act. So it's even more broad. They leave it so broad that I do not think an ordinary citizen can fairly know what this statute's limited to. Now, finally, what I wanted to bring the court's attention to is the very last section of our paper, of the memorandum, and it talks about whether this is a result of the conduct crime or a nature of the conduct crime. And that really matters for two reasons. One, if it's nature of the conduct, which is what the committee in their notes believed it was, then you can't recklessly engage in the nature of a conduct. And so we would ask for the recklessly to be struck. However, the committee also noted that it might be, if it's seen as a result of the conduct crime, then you have to have a result. And in here, all they did is provide the conduct. They did not limit it by giving the result that we are supposed to be defending against. And so the indictment as pled would not be sufficient under result of the conduct to proceed. And we would ask that it be quashed for that reason. There's one last thing. Hold on. Where's the motion? Sorry. And then finally, I would argue that the way the statute, the indictment is pled, in and of itself shows that it's legally insufficient to be to prove torture, because it does not provide any accusation of what pain was suffered or that there was bodily pain or injury. And therefore, because all they've said is repeatedly striking, and by law, by common sense, we've seen that our society accepts horse racing and beating of horses with hard stuff, that I think that on its face, it is insufficient as pled to prove torture. It needs something more than just repeatedly striking a dog in order to constitute torture. Okay. Thank you, Your Honor.
All right, state.
Your Honor, defense keeps mentioning horses in the acts that we commit against these types of animals. However, those are livestock animals. In this case, we're dealing with non-livestock animals. These are typically in this case, cats, dogs, those kinds of things that aren't subject to the same kind of normal use and practices like a horse would be, as well as the argument about the result of conduct. She stated that we need to have a result. In this case, the result would be torture to the animal by the conduct of repeatedly striking it. And then as well, the case that was provided, I don't think is applicable here just because of the facts that we have.
All right, in the Stevens case, is that relating to First Amendment rights and the violation of First Amendment rights?
So it is a First Amendment rights case, but their interpretation of that statute as being vague is what the analysis.
But isn't it because though they were saying that it's a violation of First Amendment rights?
Well,
to
and
depict certain photos, and it wasn't about necessarily about the acts against an animal. It was more about the right to free speech.
I think the bigger part of that, Your Honor, was that the statute in that case criminalized non-culpable conduct. And the court discussed that at the end when they say that this statute is so broad to even encompass, in that case, hunting videos or something that's non-culpable. The statute was so broad, similar to, what we're dealing with here, to encompass and criminalize non-culpable conduct. And I think that the issue is the same here, and that statute was even more specific than a good deal more specific than this statute.
But it's about First Amendment rights. I understand that sometimes you will have appellate courts. They will make a ruling on the issue that is specifically before them. And then you may have other members of appellate courts who will do a dissenting opinion or a consenting opinion, and then they want to add things that's not really about the issue at hand, but more as a signal to everybody to say, hey, this is what we're considering in general. But that case is about First Amendment rights and whether or not you could post videos of people being cruel to animals. Wasn't that whole statute related to the posting of videos and not necessarily about what we're here for today?
Well, in effect, that was the intent of the statute, was to ban crush videos of animals. But in practice, and when applying the statute as broadly as the court found that that statute was written, it encompassed a lot more than just animal crush videos, including, like I said, hunting videos, other things that, you know, are generally accepted practices that, you know, we would consider non-culpable. And I think that's the bigger issue with it. It encompassed more and criminalized more conduct than necessary, without, you know, a level of specificity to give the average person notice of, you know, what conduct that the law is criminalizing. And I think that's what the problem was in that case. I think that's what the problem is here.
Oh. Just one moment. Let me review some law.
Your Honor, I needed to add one last thing, because I do believe this also triggers First Amendment protection. While it's not,
Well, just one moment, and then I'll let you say that. So with regards to the Stevens case, it appears that Congress changed the law and they made it a crime to knowingly create, sell, market, advertise, exchange, or distribute any animal crush video. And then they defined what animal crush video is. That depicts actual conduct in which one or more non-human animals is intentionally crushed, burned, drowned, suffocated, impaled, or otherwise subjected to serious bodily injury, and two, is obscene. So they address that. But in this case, the Stevens case, it was about First Amendment rights. And you say you want to address something with First Amendment rights here?
yes, because conduct is also, First Amendment also reaches conduct. And in this instance, there are First Amendment rights. We have a right to conduct our lives in First Amendment, like in our actions, in our words. And there are words that are taken in this instance, as well as actions that substantiate or like back up the words that are used. And she has a right to express herself, and her belief of what is right and wrong as far as discipline is protected by First Amendment. Whether we agree with that or not, someone's position, they still have the right to express themselves. And here, I do believe it's broad enough to also trigger First Amendment rights, because she's talking, she is expressing a position, and so in that regard, if you were to criminalize this, you'd also be triggering First Amendment rights of what someone believes, and it was on a video that is then publicized.
All right, what do you mean she's talking and expressing an opinion? Because I don't see that in the indictment. Is that some fact issue?
Well, it is that it reaches that, like that First Amendment is going to be triggered because she does express an opinion as to why the dog is being repeatedly struck. And so it's all in the context of.
All right, when you say express opinion, I'm trying to understand. I'm sorry for interrupting you, but I'm trying to understand your argument. When you say she's expressing an opinion, are you speaking about your client?
Yes, there is in this case, there's an opinion stated. So this case is broader than just act. It's also speech, it's conduct, and repeatedly striking is a conduct in regards to discipline. And so discipline is protected by the First Amendment. You have the right to discipline and speak your discipline and to conduct your discipline.
Okay, I'm sorry. I'm trying to understand your argument because it appears that this is beyond the indictment, but are you saying that your client made some statements in its protected speech?
Yes.
All right, so does that go with the voluntariness of her statement argument?
No, that is a separate.
I don't see how the court is legally allowed to go outside of the indictment when you're saying a motion to quash, because now you're bringing in facts that are not in the motion. I'm sorry, that are not in the indictment, because nowhere in the indictment does it state that there was a film. Nowhere in the indictment does it state that your client gave statements. So it appears to the court that what you're arguing now are fact issues. If the court denies your motion, they're fact issues for the jury, not for a motion to quash.
And I understand the court's position and agree that that is probably more as unconstitutional as applied argument that would be more appropriate at the end of a case than right now, when we're just looking at the face of the document of the indictment and the statute. But I would just say that repeatedly striking a dog is conduct, and conduct is protected by the First Amendment.
So you're saying striking at a dog is a form of speech?
Yes,
All right.
because it's a form of conduct that it is by its essence related to discipline, care, control of your animal.
So then any type of conduct, be it against an animal or a human, then would be a form of speech.
It could be, but it could also not be a protected form of speech. That's possible.
All right, State, she's saying striking an animal is a form of speech and it's protected.
Your Honor, we were just asking you to look at the indictment on its face. We haven't alleged anything about discipline, anything about speech, anything about a video. We've merely alleged torture. By repeatedly striking a dog, we would assert to the court that regulation of conduct only implicates the First Amendment if it qualifies as expressive conduct akin to speech. But I don't see how it applies here, really.
All right. All right, with regards to the motion to quash, the court has heard arguments from both sides. The court has reviewed the case law that has been submitted to court. The motion to quash will be denied.